Hey everyone, it's Rob Ryder. Tuesday, April 2nd, 2013. Um, we're all looking for justice, and it's, the quest continues. So let's see what we can find in history and in present day to use to our advantage, so that we can put a criminal complaint in to report a crime to the right people. And I had sent this out yesterday. It was one of the things I came across putting stuff together for this particular video. It's the origins of public prosecution at common law. So let's begin. This may take a while. Just go till we're done. However fundamental he may appear to us, the public prosecutor has a historical latecomer. Judge and jury we can trace back to the high Middle Ages. Prosecutor became a regular figure in Anglo-American criminal procedure only in Tudor times. Further, his appearance then has not been noticed in our historical literature, an especially remarkable omission when we discover that the prosecutorial office was originally lodged in a much studied institution, the English magistracy. Ever since Martland coined his famous phrase that under the Tudors and Stuarts the justices of the peace became the rulers of the county, they have attracted a substantial scholarship. Nevertheless, this major aspect of work of magistracy has remained unknown. I wonder why they wouldn't want you to know these things. The present article documents and accounts for the development by which the justices of the peace became the ordinary public prosecutors in cases of serious crime. Now, the reason that's important is people have tried putting in complaints before, maybe going to the sheriff's station and told to fill out a statement, police station statement. Well, that's a witness statement, and you're going to be when you look at them, you're the complainant witness, but you're not the complainant. So there really was no complaint filed. That's what a cop does when he gives you a ticket. He's going to be the complainant witness. There is no complainant. And so when they do it that way and take you to court, well, that's a simulating the legal process. But it says here that the justice of the peace became the ordinary public prosecutors in cases of serious crime. So you may want to write this down, because it's just a PDF online, The Origins of Public Prosecution at Common Law by John H. Langbein. And if we go up to here, it says, because I'm not reading this whole thing, this is just how we're getting started. Well before the Marian statutes, the JPs were the officers to whom aggrieved citizens could make complaint of serious crime. We're talking crimes, we're not talking civil matters. If any court case that you're in, look at any piece of paper on there and find me a frickin' court seal. You're not going to find it, right? They're simulating a legal process. That's a crime. I don't want to do a civil action against them. I want to go put in a criminal complaint. So, where do we go next here? Let's look at some history from Sir Frederick Pollock. He passed away in like 1930, I think it was, and so he had done I don't know if he edited Blackstones or just contributed to the editing of a Blackstones, but one of the versions of Blackstones, when you get into the stuff Blackstone talks about, and then at the bottom of the page it's all the small print, the read between the lines stuff. In one of the editions, this gentleman, Frederick Pollock, had a lot of things in there, and as it turns out, he wrote a lot. This is very interesting. I can get it as big as I can get it. My eyes are getting bad, and I like to sit too close to the computer screen. Okay, all existing civilized communities appear to have gone through a stage in which it was impossible to say where the private vengeance for injuries ended and the public retribution of offenses began. Or rather, the two notions were hardly distinguished. First revenge approved as no more than adequate, or disapproved as excessive, by rough public opinion, and even when deemed legitimate, constantly leading to the reprisals and fresh feuds. We're talking about blood feuds here. That uh, McCoys and who were they down in Kentucky? Campbell and McCoy? I can't remember who they were. Anyways, blood feud. Um, and or his kindred, if he was slain, to be content with compensation on the proper scale, if duly tendered and secured. Then the addition of punishment, or substitution of punishment for compensation, turning the avenger into a prosecutor who must hand over the business of execution to the public authority. So you weren't going to execute your own judgment, you were going to have it prosecuted for you. Finally, the staying of private avenger's hand and the repression of crime by direct application of power at the disposal of the state. All this has been seen on more or less distinctly traced in the history of criminal jurisdiction and law in many lands, and it's abundantly exemplified in our own. We can find already established in the 11th century the king reserves a certain number of greater crimes for his jurisdiction. In the 12th century, the list is considerably increased and may be said to include all serious offenses against a person other than open manslaying, and also highway robbery, besides breaches of the king's special protection, false money, and other contempts of his authority. Basically, felonies. The omission of homicide in general, so strange to modern ways of thinking, is accounted for by the fact that rights of the kinfolk were supposed to be exercisable. Secret killing, especially by poison or supposed witchcraft, for to this the same of murder seems at first to have been attached, could easily be reserved for the king's particular jurisdiction, because the ancient process of an actual or commuted blood feud, assuming as it did that the facts were notorious or at least easily verifiable, had no adequate means of dealing with such cases. So pretty much in the old days, if somebody killed one of yours, you could go kill one of theirs, apparently. But there can be little doubt that the anomaly of leaving open homicide to the kindred and the popular courts was already obsolete in the practice by the times when the list in question was set down by an antiquary who perhaps would not have approved the innovation. Murder, indeed, had acquired the curious transitional meaning of a homicide committed by an unknown person, for which the hunted had to pay a fine because the slain man was presumed to be a Frenchman, or more frequently by a compendous technical usage, the fine itself. Don't really know all that stuff's about. We'll get on the other stuff. These claims on behalf of the crown were quite consistent with the lords of private jurisdictions having power of criminal justice extending in many cases even to life and death. Indeed, their exercise of such power could be justified only by the highest theory of the king's power. It was because the king had them himself to begin with that he could grant them over to the great lord whom he chose to favor. On the whole, the particular result was that the pursuit of serious crime was taken away from the old local courts and came under the control of the king's judges and officers. So what the king did is he, back in old England time, everything was a county. They all had county courts, had local courts, all sorts of courts. Now we have a kingdom, because the counties existed before the kingdom did. And so the king had royal officers, and he basically took the jurisdiction away from the local courts and gave it to these royal officers. The precise manner in which it was brought about is under the cloud, which envelopes most of the details of the Anglo-Saxon institutions and their transition to Anglo-Norman forms. But it is certain that early in the 12th century, the compiler of the so-called laws of Henry I represented the old system of blood feud tempered by acceptance of weregild, which is basically pay money for it instead, and a very moderate amount of royal interference as still in force. whilst in the last quarter century, at least, we find that the greater crimes have acquired the Norman name of felony. The prosecution of them conducted under the name of appeal. So an appeal is actually the prosecution of a felony by the person who, under the older law, might have taken up the feud, but the procedure is under the king's authority as soon as started and cannot be dropped without leave. The mode of trial, where the fact is denied, is by Anglo-Norman judicial combat, or from the early part of the 13th century onwards, by verdict of a jury at the option of the accused. So, the greater crimes became known as felonies, and their prosecution became known as an appeal. And it was a procedure under the king's authority as soon as started, and cannot be dropped without leave. Once you put in a criminal complaint, basically there's no stopping it. And the conclusion, if the accused to be proved felon by failing in battle or by verdict, is the sentence of execution of public justice. One grim piece of archaism remained far into the Middle Ages to mark the original place of tribal and family revenge. By the ancient law, one of the judges in 1409, when one is hanged on appeal of a man's death, by one is hanged on an appeal, so on a complaint, criminal complaint of a man's death, the dead man's wife and all his kin shall drag the felon to execution. That has been so in our time, added Chief Justice, whoever it was. As to the name of the proceeding, appeal originally meant accusation. In its application to disputing the judgment of a court, it meant not seeking the judgment of a higher court, as it has come to do in modern times, but charging the judge personally with giving willfully false judgment, or the witness with perjury. And again, you look at a court case you have going now, there's no court seals on this paperwork. There's no complaint been put in by the plaintiff. Right? These are all, it's a willfully false judgment and perjury by the witnesses. So when you would appeal a court case, you wouldn't appeal to overturn a judgment. You would say the guy made a willfully false judgment, or that the witnesses had committed perjury. The charge might in either case have to be made good by combat, and down to the end of the 12th century this was possible, of course, in all inferior courts. Solemn acts of authority must stand, right or wrong. A judgment once made in due form of law of the Medes and Persians, which other not. You may have at most a personal remedy against individuals who have abused their office. A power vested in one court to reverse or vary the judgment of another is not within the concept of English or Frankish law. Right? The power vested in one court to reverse or vary the judgment of another was not within the conception of early English or Frankish law. Such a notion is of slow and comparatively modern growth in England. The modern usage of the word appeal, implying the notion, seems to be not older than near the end of the 13th century, and to occur first, as might be expected, with reference to ecclesiastic procedures. To return to what concerns us at present, it was well understood in the 13th century that the criminal appeal was no longer a mere act of private vengeance. The king had to be satisfied for the breach of his peace, as well as a aggrieved party for the injury. And, okay, so when they're talking about this appeal, applying to notions in the ecclesiastic procedures, one of the problems with common law is the law doesn't, the way the lords wrote the laws, because this is Parliament writing this stuff, right? Basically, whoever holds the legal title is the owner. But they didn't put in there unless they got it by fraud, right? So somebody came into your house midnight, stole your deed out of your house, and he had it the next day. Hey, he's the owner. Come fight me for it. right? So the ecclesiastic courts, so that would be a in rem jurisdiction case in the courts, because we're talking about who owns the property and he has the legal title. That's what's happening to you in court. You'd have to go to the ecclesiastic court and say, yeah, but he got it by fraud, right? He broke one of the 10 Commandments. And so that would be an in personam jurisdiction, not against the property, against the person who took your property. So you would appeal, I guess, to the ecclesiastic courts, because based on the law, they gave the judgment to the plaintiff, but nobody cared that the plaintiff stole your property. All that mattered is he had the legal title to the property. Hence, as Bracton expressly tells us, the death or default of appeller did not make an end to the other proceedings. On the contrary, the effect was to send the accused to be tried by a jury without an option of battle. The king takes up charge on behalf of his own peace, as well as he ought, for the words of the appeal are that the act complained of was done wickedly and in felony against the peace of our Lord the King. So for myself, I can say my Lord the King now is Jesus Christ, and he rules the earth, right? They're breaching his peace. They're breaching God's peace. God gave them 10 easy commandments to follow. If they can't follow them, they need to be rebuked. Coveting my property is one, right? Theft, lying, lie, cheat, steal. And the accused may not offer to defend himself by his body, since the king fights not, nor has none other champion than the country. Thus it only remained for the accused to put himself on jury, no other mode of proof being possible. But in the matter, as we have presently seen, Bracton and his masters were too enlightened for their age, and their sensible practice had given way to an almost incredible combination of pedantry and barbarism. A pedant is a person excessively concerned with formalism, precision, who makes a show of his or her learning, right? So they had this great idea that we're going to give the jurisdiction of the king. Well, the king can't be involved in battles. The king fights not, nor has none other champion than the country. Because back in the old days, you could have a battle over this, and you could each pick a champion, go get the best knight and pay, and whoever won, well, that was the winner of the contest. And so we're going to take it out of the private hands, put it in the king's hands. The king can't be involved in a duel. So now all he has left is a possibility of a jury. And while it was good at the time, things have happened to juries since that, have some problems. So meanwhile, the old public justice, applicable to cases where there could be no question of a blood feud, practically that is, to theft, was becoming the king's justice too. Okay? No question of a blood feud, particularly that is to theft, right? You're stealing stuff, that's going to start a feud. The men of the 100 who charged a suspected offender on the strength of their knowledge or of common fame now acted under the direction of the king's officers, and the withdrawal of religious sanction from the ordeal by the church 1215 brought further proceedings under the same authority. By the downright need of some new regulation. The action of the Lateran Council was promptly enough acknowledged by the kings, calling for appropriate measures. And so what they're talking about here is basically they used to have the ordeal. They dunk you in the water. If you floated, you were guilty. If you sunk, well, they'd pull you up before you drowned. But you had to go through the ordeal. Burn your arm, burn your hand, check it in a few days, see if it's healing. That's how they decided if one was innocent or guilty. It was the so-called judgment of God. It was now regarded as possibly oppressive or fraudulent judgment, which might call for supernatural redress. On the other hand, the temporal power was not disposed to regard acquittal on a trial by ordeal as conclusive in the prisoner's favor. A man of bad repute who had been sent to the water on charge of murder and other grave crime by the witnesses of the county was not treated as innocent by the later 12th century practice. Under King Henry's ordinances, he was to leave the kingdom and be content to forfeit his goods, or not to forfeit his goods. A mode of trial so little respected had become untenable. When ordeal was put out of the way, to all seeming unregrettable by anyone, there was no method of final proof to set in place other than a new and royal method of inquest. If the accusing body had been turned into final judges of the fact, some sort of inquisitional procedure would probably have been the result, and the grand jury might have become a public staff with a public prosecutor at its head. But the law maintains the old view that the indictment, as from this point we may begin to call it, was only the voice of common fame, which was enough to put a man in jeopardy but not condemn him. The prisoner was entitled to call for the final vote of lawful neighbors to put himself on the country. The same men might now be asked their definitive opinion, but they were reinforced by jurors from another 104 townships, and of the 4 townships. If the combined jurors declared that they positively thought the prisoner guilty, he stood condemned. Only in the middle of the 14th century were members of the jury of indictment prohibited from serving on the jury of trial. So basically you get 2 juries. The jury of indictment and then at the trial. And so the way it used to work is every town or whatever, every 100 had a jury, and they kept control of what was going on. They were the court of the 100. And if somebody broke the law within there, they held a jury, decided if he was guilty. If he was, boom, and then it would go to a final trial. So the jury was really like the police. It will be observed that new process brought into play in point of form by the prisoner's actions. He is not sent to a jury as he would have been sent to the ordeal. He puts himself upon its verdict. Before long, the question arose that has to be done with the prisoner who would not put himself on the verdict of a jury in the case of either an appeal or an indictment. This is not a question directly before us now, but it was inevitable and gave such trouble. When the judgment of God by ordeal ceased to be available, it seemed, on the whole, to the medieval English mind, that the prisoner, except where the facts were too manifest to need further proof, could not be required as a matter of strict right to submit himself to any form of human judgment. That's what he's thinking, old England. I don't have to answer any form of human judgment. I answer to God. Bracton, as we saw, was bold on the side of common sense in the case of an appeal. Now remember, this is an appeal as far as an indictment. A criminal complaint. As to an indictment, he only says it seems that prisoner can be compelled to defend himself by the country for want of other manner of proof. Some bold and enlightened judges, probably Bracton among them, were prepared to dispense with consent or enter a fictitious consent to be tried by a jury on the prisoner's behalf. But the formalist view prevailed, namely that the trial by the country, should not be without the prisoner's submission, but refusal to submit was an independent offense in the nature of contempt of the king's authority, for which the defendant might be punished in any manner short of death, imprisonment, rigorous imprisonment under conditions barely compatible with living, or, as the practice appears to have been settled in the course of the 14th century, with aggravations amounting to death, in fact, though not in terms. The trial by the country could not be without the prisoner's submission, but refusal to submit, so not going before the jury, um, was an independent offense and the nature of contempt of the king's authority. And boom, now we got you for another crime. In this way, respect for the letter of the subject's rights and dread of usurping jurisdiction led the judges to a clumsy and barbarous expedient of, basically, this is hard labor. Son of a biscuit. One of them days. Which to law's disgrace remained possible and sometimes put in force down to quite modern times. Hang on just a second, please. But strange were the limitations imposed by the logic of 13th century lawyers on the king's jurisdiction. The jurisdiction had, in substance, come to the king's hands. What remained in practice time of the old system of private and vindictive prosecutions became absorbed in one or another of a few varieties of civil procedures devised by clerks in the courts in the king's chancery and sometimes by the judges themselves. We have mentioned the exceptional cases, perhaps not so exceptional in days of open violence was frequent, of crime being too manifest for any formal proof to be required. A few words of explanation must now be added. For more than a century after the conquest, and much later in some local jurisdictions, the stern rule of the popular courts against open notorious crime held its ground. A criminal taken red-handed was not entitled to any further defense or trial before the king's justices, whether he were a murderer with his bloody weapon or a robber with the stolen goods, seized, as men then said, of murder or theft, so that the fact was undeniable before lawful men who apprehended him. This was deliberately confirmed as late as 1176, and the jurisdiction as long as it existed remained in the county court, save for cases specially reserved to the crown. In some Gloucestershire records, we read that certain evildoers slew a servant of the bishop. 4 men charged in killing were taken with stolen goods, the murder having, it seems, incidental theft of the housebreaking. Records show the very common state of things, and as there was nothing more to be lost by adding murder to robbery, already a capital offense, we need not be surprised. The men admitted the death and were summarily hanged, not for the murder, for which was not within the county court's jurisdiction, but for the manifest theft, which was. So theft was in their jurisdiction, and it was a capital crime. They hung them for theft. Murder would have had to go on to the king. The same rules applied by the king's judges to manslaying down to the middle of the 13th century. It was not necessary for the judgment should be rendered immediately, but damaged circumstances, the offender's arrest, should be promptly recorded by good witnesses. A written record of such cases are of a simplicity befitting the summary character of the proceedings. Welkin Ralph's son slew Martin Day with a knife, and was taken thereupon with the knife all bloody, and this in witness of the township and 12 jurors, so that he cannot deny it, let him be hanged. He has no chattels. An important exercise of the king's increasing control over criminal business was the constitution or definition, it is not certain which, of the office of coroner in 1194. The most important function of the coroner was from the first the holding of inquest on bodies of persons who had died of violence or accident, or in circumstances giving rise to suspicion, and that function continues to this day as part of the machinery of our criminal law, or in circumstances giving rise to suspicion, right, a complaint, side by side with the jurisdictions of justices of the peace, and to some extent overlapping it, but not superseded. So the coroner is above the justice of the peace. Because, as we'll see, the coroner is a royal office and the justice of the peace is a legislative office out of Parliament. In the Middle Ages, the coroners also exercised judicial powers in criminal and sometimes civil business, which did disappear partly under the express prohibition of Magna Carta, where neither coroners nor county court were to hold pleas of the crown. I love my pleas of the crown. Plea of the crown is a complaint in which the king is a plaintiff, partly by disuse, as the office of Justice of the Peace was brought into working order. So what they're saying is, by the Magna Carta, that the coroner could not try a plea of the crown, a criminal complaint. That's what they mean by holding it. They supervise execution of capital justice, right? So since they couldn't do it, but they had the Justice of the Peace, well, the Justice of the Peace are going to do it. They supervised the execution of capital justice in the privileged jurisdictions of the lords who had that franchise and thus had more extensive rights than the sheriff, who, by the terms of such local privileges, were excluded from interference within their bounds. Being the king's officers, but elected by men of the county, the coroners formed a direct link between the crown and the people and a check on the intermediate lords. Now, who is the coroner? Well, way back a year and a half or so ago, when Jason wanted to put in a plea of the crown, a complaint upon which the king is a plaintiff. And we had found out that the probate court was a court of inquisition. So he went down to put in a complaint in probate and ended up talking to the probate registrar, who did take his complaint. And the complaint was against another county officer who had taken his public record and tore off the certificate of authority, destroyed a public record. And the next day, or the same day, I can't remember, they did another one with his buddy in court and gave him a plea of the crown. This is all on an audio from way back when. Very interesting story when it all came down, that it was the prosecutor who stood up in court as the judge was running for the door. On and for the record, Mr. Gambinelli has entered a plea of the crown into this court case, and we're going to put it on the record. Something to that effect. It was a prosecutor that said that. And then soon after, he was told he's free to go, even though they'd put handcuffs on him. Within a year of the creation, or battle settlement, whatever it was, the office of the coroner, we hear of knights being assigned to each county to take an oath of all men over 15 years of age for the maintenance and the king's peace and effectual pursuit of the evildoers. This is why you need to go and take a pledge of allegiance or an oath of allegiance, the same oath that you would take if you were naturalization oath. And I think you take it with the coroner, probate court, because that's what we're talking about here. See, these coroners are formed, right? And within a year of the creation of the office, we hear of knights. These knights must have been the coroners being assigned in each county to take an oath of all men over the age of 15, over 15 years of age. That used to be the age of majority. And so sometime around the age of majority, we were supposed to take an oath of allegiance and become citizens of the United States of America. And we never did. However, if you were in the military, you've got a DD-214, as I do. I'm going to take it down and say, hey, I've already taken the oath. I just want my certificate of citizenship. The relation of these, okay, so coroners are called keepers of the peace to the sheriff and the coroners, if indeed they were always different persons from the coroners. In other words, they probably were. Right? It's not very clear. Were they the sheriff? Were they the coroner? Were they the keepers of the peace? Well, a coroner could be a sheriff. A sheriff couldn't be a coroner. And they just passed this act, or whatever they did back in the 1100s. And sent these knights out, if indeed they were always different persons than the coroners. However, they were the predecessors of the conservators of the peace. And so if you look up conservators of the peace in your statutes, You're going to find out that people are conservators of the peace ex officio, like a mayor. Police chiefs are conservators of the peace. Governor, justices of the peace. They're all conservators of the peace. You're a conservator of the peace. When you claim the king's peace as a conservator of the peace and a subject to the king, being the king of kings, you jump up in line to the highest level conservator of peace in the kingdom, outside of the king himself and his direct family. And again, a couple of years ago now, I guess it was. God, time flies. A brother named Laz in England, we were talking about this, and I said, Laz, go down and, print out Blackstone, King's Peace section at the library and have the librarian put a seal on it. Because the librarian seal makes it public record. Came out of a library, it's all public record. And so he did that, and he had to go to court, and he met some bailiff at the door who was being obstinate as hell, and so Laz sticks out the paper, says, I'm claiming the king's peace. And she looked at it and ran away. Well, she ran into the back room, and soon her boss came out, and Laz showed it to her, claiming the king's peace. I want her bond and badge number and yours. And the lady went and got it, gave it back to him in a couple minutes. Interesting things we've tried. Okay. So these conservatives of peace, first appointed under the authority of Parliament, known as Justices of the Peace, now we say of the peace, but the shorter form was a common one down in the 18th century. From the time, about a generation later, when distinctly judicial functions were conferred on them by further legislation. The Office of Justice of the Peace is the most ancient, of which it can be said that its powers and duties are wholly derived from statutes. So again, it's out of Parliament. It's not a royal office. It's an office by statute. And there's a really interesting thing. It's called the Two Sons of Oil, or the faithful witness of magistracy and ministry upon scriptural basis. It's on YouTube, and there's also books on it. It was written by a Presbyterian, and so people have had problems with what he said and so forth. But, get beyond that and just listen to how he ties these offices into Scripture. Very, very enlightening. Very enlightening. For more than 2 centuries after the conquest, the king's peace itself was liable to be interrupted by the death of the reigning king. It perished with him. The new king was not deemed fully king or so styled till he had been crowned. Evildoers were not slow to seize such an opportunity when it came. Go figure. Party time. But when Edward I succeeded the throne in 1272, being then away in England on the Crusades, the danger and inconvenience of allowing such an interregnum to be perceived to be intolerable, and the king's council forthwith caused his peace to be proclaimed throughout the nation, declaring the reason in his name in these words: for rendering justice and keeping the peace, we are now and henceforth not merely after coronation debtors to all and sundry folk of this realm. It must have seemed a bold measure at the time, but its wisdom was so manifest that it has not merely accepted as a temporary and extraordinary remedy, but became a conclusive precedent for all future demises of the crown. The doctrine of the king's peace being put in suspense by the king's death did not seem to have ever been heard of again. One reason for these, which the reform was made, may perhaps be the omission would have thrown the machinery of justice out of gear more extensively. And the writ of trespass was fast becoming into use in the course of Henry III's reign. During the 22 years between the middle of the century and his death, it became common. We think of an action of trespass nowadays as purely a civil remedy, a means of recovering damages if the plaintiff succeeds, and that was no doubt its main object and advantage even from the first. but it was also a penal and semi-criminal proceeding and preserved traces of its character down to modern times. A trespass was complained of and dealt with as a punishable breach of the king's peace. This is one of the tactics they use against you. They're claiming trespass, that this property, the defendant in a court case, because it's the all capital letter name, it's your estate, it's an in rem jurisdiction, and in rem it's about the thing, as opposed to in personam, about the person. So the case is the thing. And so when you go into an in rem jurisdiction, even if you go pro se, you're still the attorney. You're the attorney for the thing. The thing is the defendant. It's a fiction. That's how courts of law work. They work on fictions. Courts of equity work in personam. They work on the man. So they go in and they get a writ of trespass, or start a case in trespass for no determinable value, less than 40 shillings. And they're going to get damages somewhere else because you're not going to answer the trespass. Now they're going to claim damages. And so this is happening in another court than the court you're going into, because the court you're going into doesn't really even exist. You know why? There's no court seals in the papers. Okay. In fact, this action was, in its original form, closely connected with the distinctly criminal procedure by way of appeal for felony. In other words, you took a complaint to the Justice of the Peace. That's what they're doing now. In fact, they got a special one for it. And it's going to be 2 or 3 hours of video, so it might be a while till we get to it. One might almost disregard it using the analogy of modern French procedure as a civil side of such an appeal, which became separated from the ingenious experiment, happy accident, yada yada yada. To regard the king's peace as capable of temporary suspension would have deprived suitors of remedy, which is already becoming popular, and showing the first promise of vast future developments, which it has been. It belongs to another context and later period to see how forms of action derived from semi-criminal writ of trespass became almost ordinary and efficient instruments in purely civil justice in dealing with questions of property and contract. They can't make it any clearer, man. They're using a writ of trespass against you. A semi-criminal offense. And so it's done by appeal, and an appeal is something taken to the Justice of the Peace. It's a criminal complaint. It will be observed that there is no centralized authority, as indeed there is still none, for dealing with the prevention and detection of crime. Royal justice aimed not at superseding local administration, but at controlling and stimulating it. The work of the king's officers in every department of public law and the local officers and courts were bound to assist them was kept up to a generally uniform standard by periodic journeys of the king's internet judges. That would be the appeals court, Michigan Appeals Court, which is actually Michigan's highest court. If you look at the court seals for the courts, and you read in the Michigan Constitution, there'll be one court of justice consisting of a Supreme Court, appeals court, probate court, circuit court. And you look in the statutes, it says they all have a common seal, and you go look at the seal. Those courts all have the what is called the coat of arms for Michigan. And then if you put a certain ring around it, it makes it the Great Seal. And if you put other rings around it, depending on the court, it makes it a court seal. But you look at the Michigan Supreme Court that we think is a Supreme Court, they don't have that seal. They don't have the coat of arms of Michigan. Right? I don't know where their court comes from, but it's not the Supreme Court. The Supreme Court is actually the appeals court when the appeals judges all get together to form the Supreme Court, just like in territorial days. The more general searching visitations have to be distinguished from the minor judicial delegations. There were frequent missions of learned persons charged only to dispose of certain kinds of pending causes and matters, usually the assize, developed in the course of the 13th century recovery of land from wrongful possessors. Excellent. We got wrongful possessors. We're not in possession of our property. as far as legal title is concerned, somebody else has it. That's why possession is 9/10 of the law. They're holding the legal title. You're not. But they have wrongful possession. We're going to try to get it back. Judges might even be sent out to take only one particular named case under a special commission, as we should now call it. Their authority depended on terms of the commission in each case, as the authority of justice of the assize does to this day. See, you got justice of the peace and you got justice of the assize. What's the same? They're both justices. The difference is that the commission of the justice of the assize, who superseded the justices of Eyre, have run in fixed form for centuries, whereas the head or articles of the Eyre were subject to variation. Okay, so the justices of the assize, that's what you would think of as a circuit court judge going around the circuit. And if you look at the people that sit on the appeals court in Michigan, yeah, they sit in the appeals court, but they also go around the circuit, hear cases in different courts other than the appeals court. More especially, there was a general and comprehensive mission with unlimited jurisdiction and wide administrative authority to see the Crown got its dues of every kind, which took place at intervals from some years in every part of the country. This may conveniently be called the General Eyre. It involved a rigid scrutiny of the criminal records of the county since the last visitation and commonly produced a good many fines. These and the burden of entertaining the justice of the retinue caused the advent of General Eyre to be anything but welcome. Attempts were made to establish custom of having it in the same place more than once in 7 years. Go figure, that's where that 7 years comes in. They got to destroy those records within 7 years, because if the judge came and saw the records, right, he'd say, hey, these don't have any court seals on them. Something like that. There's some reason that they don't want them around for 7 years. On these occasions, the county court was summoned, but acting in a subordinate capacity of giving information and deputing the chief men to talk over the business with the judges, and we may well suppose to be instructed by them in the latest royal improvements of procedure and finance. When the men of the county were answerable for having all the Crown's business property brought before the itinerant judges, and that business would include everything from forfeitures of felons' goods to complaints of sales by unauthorized measures or petty extortions by bailiffs. Directly or indirectly, there was always an eye on the king's dues. A distinction between doing a penal justice and the collection of the king's income is only gradually emerging. The itinerant judges of the 12th century have much of the commissioner of taxes. Failure to find criminals, what with murder fines and amerciaments for failing to produce one's townsmen, was more fruitful of revenue than judicial sentences. Unpleasant as the whole process was for the county side, for it was a costly forced purchase of justice at best, there must have been a great deal of civic education in it. So failure to find criminals, what with murder, fines, and amerciaments for failing to produce one's townsmen. Okay, so these judges come in, they got all these criminal offenses on the books, but nobody produces the townsman, so they give the county a fine. Happens every 7 years, apparently. So far, we've only hinted at the transformation of a jury in criminal cases from a special commission of inquiry into regular necessary tribunal, and for peace and superior administration machinery into popular representative institution. Many details are still obscure, but we know that the process was substantially completed by the middle of the 13th century. What interests us here is to observe that nothing but the king's power, half consciously guided by the necessities of time, could have accomplished this. There were no means available for reforming the hopelessly antiquated procedures of old popular courts, and indeed there are still, in modern sense, no legislature at all. So in local courts, it's all just done by custom. There is no legislature. What's a local court? Like the county court. As opposed to the circuit court, which is the itinerant judges going to each county. Executive and judicial authorities, under the king's direction, had to innovate for themselves in lines of least resistance. As early as 1166, the old accusation by the common report of the county side became a presentment by definite persons representing the local knowledge of all cases, who were bound to inform the king's judges or sheriffs. In our time, the grand jury no longer consists of 12 of the more lawful men of the 104, of the more lawful men of every township, but it still exists, it being called a grand inquest, and its most official and solemn name, the foreman is sworn as foreman of this grand inquest for the sovereign lady, the queen, and the body of this country. Grand inquest, you could take your complaint to him. The form of oath still binds the grand jurors to present any crimes undiscovered by the officers of the law which may come to their notice. In other words, you give them a notice, hey, a crime's been committed. Here's my complaint. Otherwise, then, by being expressly given them in charge, that is, to accuse any one whom they suspect of having committed a crime, even if no one has taken steps to prosecute him. And though there is no occasion to do this in modern times, grand juries not infrequently make presentments of what they conceive to be opinion of the county as the increase or decrease of criminal offenses or desirable amendments of the criminal law in substance and administration. Okay, that's the grand jury. It is to be remarked that the form of oath is not Anglo-Saxon or popular, but of Frankish and official origin. There was nothing about the procedure in any way repugnant to popular tradition of habits. Nevertheless, it was new, royal, and ultimate parentage exotic. Not the pretense of an impossible freedom from foreign elements, but the power of assimilating exotic material to serve its own purpose and to be leavened with its own consistent spirit was already, as has been seen, the real glory of our common law. Sometimes it is asked, what use is a grand jury nowadays? The question ought, perhaps, rather to be whether the saving of a little trouble and expense would be an adequate compensation for abolishing a dignified and worst harmless function which has been part of the machinery of justice of England for more than 8 centuries. However, the grand jury is sometimes able to stop an obvious malicious or frivolous prosecution and spare an innocent person the pain and scandal of going into the dock. The petty jury acquires its modern position, that of a body of judges appointed to decide the facts according to the evidence and not otherwise, only by a gradual process. So the grand jury has been replaced by a petty jury, a body of judges, a quorum of justices of the peace. As a result, the criminal jury we still know little of. As regards the criminal jury, we still know little of the details. In the 15th century, the functions of jurymen were coming near their present character. In the 16th, we have description of the course of trial, which, but for the prisoner not being allowed to employ counsel against the crown, would be accurate in its essentials at this day. Sir Thomas Smith, writing chiefly for the information of learned foreigners, insists on the public and oral character of the procedure, a matter commonplace in Englishmen, but strange to men living under systems derived from Roman law. Okay, I'm going to have to shut this off and pick it up on another video.